So moving on, I don't know what happened here. I accidentally cut off Bill, Mary, and Bo's heads. So forgive me for that. So we've got here Bill and Mary were married again. And let's say it's been quite some time after Bill has passed. And Bo, the tennis pro, who has always held a torch for Mary, professes his love for Mary, and they fall in love and get hitched. In this circumstance, again, if Bill died without an estate plan, what happens with Bill's assets when Mary marries Bo? Okay, let you think about that. So in this circumstance, and I know this is overly simplistic, but again, Bill and Mary held everything jointly. Bill passed away. Everything then went to Mary. When Mary gets married to Bo, she says, okay, so what do you do when you get remarried? Well, I put my new spouse on as as a joint owner of my bank account and joint owner of the house. Okay. So now when Mary passes away, so I'm sorry, in this circumstance, let's say, well, Bo is a really good guy. Bo knows that um, Bill and Mary did not intend this to happen. They don't really intend Bill's assets to go for the benefit of Bo. And so they use those assets, Bill and Mary's assets, for the benefit of little Bobby and Susie here. Okay, so everything's working out fine. But what happens when Bo passes away? I'm sorry, if Mary passes away. Okay, Mary passes away. Now everything, again, now Mary had put Bo's name on everything. So now Mary passes away and everything ends up with Bo. Okay. Maybe she's put him on, like I said, jointly on the bank accounts, jointly on the house. Maybe she's named him as a primary beneficiary of her life insurance or retirement plans as the surviving spouse. Again, you say, now, if you're Bill and Mary looking down at this situation, how are you feeling about this? Okay. Again, let's say Bo is an upstanding guy. He says, no, I know this is not what was intended. Mary and I talked about it. In fact, Mary died in a car accident on the way to the estate planning attorney's office to sign the documents. Okay. So Bo says, I'm going to do the right thing and I'm going to give this money to the kids because it's really not mine. So there's a gift tax. Bo then is making a gift to the kids, and there will be a gift of 30 to 45% to be paid. 35 to 45% of whatever is given must be paid. So let's say it's $1 million. That's 300,000 to $450,000 of gift tax. So who pays the gift tax? Is it the kids or does Bo pay the gift taxes? The answer is Bo pays the gift tax. So if Bo pays the gift tax, what incentive is there for Bo to do the right thing? Not as much, right? Okay. So what could have happened is, again, in a joint trust, the trust is set up so that it splits into two upon the death of the first spouse. And we can build into the trust what we call remarriage protections. Now, these protections that I'm talking about can only be built into the decedent's trust, which you see there's a lid on the box because that trust or the terms become irrevocable or unchangeable upon the death of the first spouse. Okay. And so what we'll say is when Bill and Mary are alive and well and they're sitting in the estate planning attorney's office, they'll say, hey, you know what? If I'm the first to die, I want you to move on. I hope you be married and you can be happy again. But let's agree that if you do get married, that you must get a prenup. Okay. And that prenup is going to state that any monies coming from the decedent's trust for your health, education, and maintenance is only for you, the surviving spouse, and your sole and separate property, and will never become part of the community property with you, the surviving spouse, and your new spouse in your remarriage. Okay. So we're going to write that into the trust together, and the trust is going to state if you would like to continue to receive these distributions from the decedent's trust, you must enter in a prenup stating that. failure to get that prenup for whatever reason, maybe you bring it up to your new soon-to-be spouse and they balk at the idea, they get angry, and so you don't execute it. Or maybe the surviving spouse themselves does not want to bring it up. It's not brought up. It doesn't matter why it doesn't get executed, but it doesn't. If it does not get executed, the prenup does not get executed, then what ends up happening is the surviving spouse is removed as a beneficiary from the decedent's trust. They are also removed as a trustee of that trust. And whatever is in the decedent's trust will go to your remainderment beneficiary, which in this case, most likely for uh, a traditional couple that has children or maybe just other beneficiaries, whoever they are, that whatever is left, whatever is in the decedent's trust will be distributed to them immediately, since the surviving spouse, if the surviving spouse fails to get a prenup executed prior to their marriage. Okay? So again, this remarriage protection can only be built in the decedent's trust. The benefit of this is it takes the pressure off of the surviving spouse to do this on their own. They can say to their new spouse to be, hey, I had nothing to do with this. Look, when we executed this trust, when my ex-spouse and I, or my late spouse and I executed the trust, we hadn't even met. It has nothing to do with you. This was just the agreement and it can't be changed. So it takes the pressure off of the surviving spouse to take the steps to protect those assets for the benefit of the remainder and beneficiary. Just makes it a lot, I think, easier, an easier thing to do. Okay. Whoops. All right. So divorce protection. So again, going back to Bill and Mary. Bill and Mary again, married, high school sweetheart. Bill has passed away. Everything has gone to Mary. Mary's managed those assets very well, used those assets for Bobby and Susie as they grew up into adulthood. But now Mary is getting on in age, okay? And Mary says to herself, well, why should I bother planning? Nothing bad happened. Bill and I never planned. And when Bill died, I just got everything. There was no probate. I didn't have to go to an attorney. I just had to go and show a death certificate and maybe get something recorded with the recorder's office. But it was really not that big a deal. No estate taxes were due at that point either. So Mary just never gets around to planning. Now, so what happens when Mary dies? In this circumstance, whose name is on the deed to the house that Bill and Mary had together? It's just Mary. Okay. Whose name is on the bank account that they had together? It's just Mary. Mary's name is the only name on the investment account. And so when Mary passes away, all of those assets, Mary's estate, the assets in which the assets that are just titled in her name alone have to go through the probate process, and they do eventually end up with the two kids equally, Bobby and Susie, through process of probate, but also what we call intestate succession, because she died without an estate plan in place. This is where they say if you die without an estate plan in place, the state has a plan for you. It says in this circumstance, Mary has passed away. Mary no longer has a spouse, but Mary does have children. So whatever she has will pass equally to those two kids. Okay. So you say to yourself here, well, hey, everything turned out fine. Why do you even bother planning? Well, let's say that in this circumstance, Bobby had married a gal named Sally, and while Mary was alive, Sally and Mary got along really well. Okay, and now Mary has passed away, and I don't know, maybe a couple of years later. So let's say Mary's passed away, Bobby's gotten his inheritance of $1 million. Okay. So 5 years later, Bobby comes home and he sees papers on the table, and they are divorce papers from Sally. And she says, it's been good, it's been fun, but I'm done and I want half of everything. And he goes into court and he says, Your Honor, but this $1 million, that's my inheritance. It was my separate property. So that should not be included in our community property estate as, as a married couple. And Sally says, that's true, Your Honor. It was his inheritance, but he was so generous with it. In fact, he dumped most of it into our joint banking account. Or maybe he had his own account and then it was connected to our joint banking account and I could take out money as I pleased. He used that money to improve our home, to do all of these other things with it. Okay. So there's an argument that Sally is making that this inheritance is no longer separate property because of Bobby's actions. Bobby has basically made a gift of his separate property assets to the community. So now what's a judge going to do in that situation? I know I'm oversimplifying it for the story, but to say, okay, that $1 million, now that's deemed community property and split it in half. And now you have your now daughter outlaw walking away with half of your kid's inheritance. Okay. So for divorce protection, we again have the scenario of a trust. We actually don't. It is not necessary to break up at the decedent's trust level at the death of the first spouse. What I want to illustrate here is upon the death of the second spouse, here was the wife. That's the second dotted line below. Whatever is left over in the decedent's trust and the survivor's trust will end up going down, will end up being distributed equally to the two kids. Okay. So now that's 50-50. So the Bill and Mary could decide, hey, we're going to give 50-50 to each of our kids. In this circumstance, I have shown it that for each child's share is going into a protective subtrust for that kid. Okay, so it's going into trust. So they have their own little boxes that have lids on them because they are irrevocable. Okay, their parents have passed away. The assets in the trust are still actually, they belong to the trust. They don't belong to the children, but the children are the only beneficiaries of that trust, meaning assets can only come out of that trust for their benefit. Okay, so money comes out. We're talking about Bobby, who is in the divorce. Money comes out for his health education and maintenance. Okay, so let's say Bobby is in the middle of the divorce, and here, because Mary and because Bill and Mary had done an estate plan and they had planned this way, assets go into the subtrust for Bobby. When Bobby is in court, divorce court or family law court, he can say, yes, Your Honor, that's right. I did have an inheritance of 50% or $1 million here in this circumstance, but it's in trust. I don't own those assets. I'm not the owner. I'm just the beneficiary. Money comes out for their health, education, and maintenance. And what happens here is that it's pretty clear that these assets never get commingled because Bobby does not have access to them to do whatever he wants with it. Okay. The terms of the trust will dictate that assets can only come out for Bobby's health, education, and maintenance, not for anything else. Okay. So Bobby is successful in keeping that $1 million out of what the family law court is looking at would be the community property estate. Okay. So that's good, right? So now you don't have your daughter outlaw walking away with half of your kid's inheritance. But let's say Bobby says, you know what, mom and dad set me up so good. So what I'm going to do is I'm going to quit my job because I know that the divorce is pending. I'm going to show that I have no income and I'm just going to live off the trust for health, education, and maintenance. Well, public policy doesn't like deadbeats, so there is case law that will allow the family law court to pierce the trust if indeed it looks like they're to satisfy child support and spousal support obligations. So those obligations are determined by what Bobby was making on his own with the spouse. So we're not going to be figuring in the amount that he gets from in the trust in that determination, but Like I said, in this circumstance, when Bobby says, I'm just not going to work, so I'm going to show no income so I don't have to pay, that's not how that works. Okay. Um, so the some people can see a benefit of this, others don't. It does not come without administration involved, and but one of the benefits is that this is something that you planning for your kids that you can offer them through your estate plan. Once they receive the assets, if you just decide to leave it to them outright, which can also be, which is a choice many people choose, which many people take, but once your child has received those assets, or once your beneficiaries has received those assets, it's very, very difficult for them to protect those assets once they've received it. Remember, the creditors stand in their shoes. If they can reach it, so can their creditors. You can't give it to them and have them give it away. Those are called domestic asset protection trusts. California does not recognize them. They are available in other jurisdictions, but beginning cost to set that up is maybe 30 to 40 grand. And so it is something to think about if that's something that you would like to offer your kids or your beneficiaries rather. Okay, so um, did anything change here? Okay, so yes. All right, so here we would have the trustee of the child's trust. It's not going to be the child himself. It's going to be a third party, typically. If you're looking for protection here, this could be a third party, a professional fiduciary, an independent, an independent trustee, maybe a trusted family member, but somebody who is maybe an aunt or an uncle. Um, and making siblings the trustee of each other's trust is not necessarily the greatest idea. And I can talk to you individually about that as to why. I've seen some cases from the litigation standpoint where that can really set up a power dynamic in the family that, despite you putting this in place for the benefit of your kids, could just end up really destroying some relationships. So that's a very important consideration to look at. Okay. So that was divorce protection. Now, you can make a plan to succeed for your beneficiary. You can put some beneficiary safeguards. We can build that into the plan. This could be um, that you require that your beneficiaries present a financial plan, that they go and they sit down with a financial planner because so they can more fully understand what assets they have of their own from maybe that they're planning on their own, but also how the assets are going to be invested in the trust for their benefit.